Hey guys, my name is Ryan Nerney, and I am a managing partner at the nationally recognized security clearance, military, and federal employment law firm Tully Rinke. Welcome to the fifth episode of the podcast for the National Security Clearance Lawyers Association. This is the very first podcast made to teach people from all industries that require security clearance, the ins and outs of the security clearance process, what adjudicative bodies look for in a potential disqualifying and mitigating conditions, and what potential and common situations mean for your security clearance. So whether you're an employee for a government contractor, a federal employee, or a member of the military, we're hopeful that you're going to be able to pick up some tidbits of useful information when you listen to this NSLA podcast. In today's episode, it's going to be a little bit of a shorter episode because we're going to continue our series where we talk about specific adjudicative guidelines for security clearances. We previously spoke about Guideline A, Guideline B, Guideline C. Today we're going to talk about one that's not really common. It's more common than maybe some others, but it's not as common as maybe Guideline B and C that we spoke about last time. But it's Guideline D for what is known as sexual behavior. So hopefully by the end of this episode, you'll have a general understanding regarding what adjudicators typically look for regarding Guideline D cases and the disqualifying and mitigating conditions for each. Now, let's get right into it. So as we spoke about in our previous episodes, you learned that any adjudicator focuses on the review of the 13 adjudicative guidelines that are disclosed in the Security Executive Agent Directive 4, which is also pursuant to Executive Order 12968. This consists of guidelines A through M. And as I said before at the outset, we're going to talk about Guideline D today. Guideline D is sexual behavior. That's what it's indicated in the SEAD for. Guideline D relates to security concerns pertaining to specifically sexual behavior. This encompasses any security concern related to anything sexual, essentially, including sexual behavior that's criminal in nature, such as soliciting prostitutes, engaging in prostitution, sexual assault, sexual molestation, sexual harassment, either inside or outside of the workplace and similar. This also encompasses criminal sexual acts in another country, sexual addiction, and the consequences of that, and even getting sexual favors at a massage parlor, whether domestically or abroad, which we see quite a bit in this guideline. Now, this is obviously not an all-encompassing list, but it is generally what we see when it comes to Guideline D. Now, some of the disqualifying conditions under Guideline D, so there's 4 disqualifying conditions, and again, these are kind of generalities. But the first one is sexual behavior of a criminal nature, whether you have actually been prosecuted or not, or even arrested. Sometimes those are things that need to be disclosed. A pattern of compulsive, self-destructive, or high-risk sexual behavior that an individual is unable to stop. This sometimes gets into any sexual harassment, maybe sexual addiction, even situations to where somebody is engaging in some sort of sexual relationship while at work. That's where that kind of comes into play. Sexual behavior that causes an individual to be vulnerable to coercion, exploitation, or duress. That's kind of an all-encompassing one. Any of these acts that you engage in can potentially do that. So sometimes if any of the conduct or security concerns don't fit specifically in one of the other disqualifying conditions, that's one that is typically utilized. And then sexual behavior of a public nature that reflects lack of discretion or judgment. Again, another kind of catch-all one under this guideline that can be utilized by the adjudicators, depending on what the conduct is. So those are the typical disqualifying conditions. Now, obviously, as you heard in the other episodes, there's also mitigating conditions that can mitigate these security concerns. Those consist of mitigating conditions A through E as an echo. This includes the behavior occurred prior to adolescence. So when you were, significantly young, and you haven't engaged in any similar behavior since. Typically that involves something, that happened as a minor. Sexual behavior happened so long ago, infrequently under unusual circumstances. This is again, it happened, quite a bit ago, years. Typically months is usually not enough to trigger this mitigating condition, but years. You don't do this again, right? And you could, provide some other information such as counseling, or, if there was some sort of unique circumstance like a sexual addiction or something like that, or maybe, there was some trauma in your childhood that kind of contributed to this behavior, but now you're seeking assistance or help for that. Those are all things that can trigger this mitigating condition. The behavior no longer serves as a basis for coercion or exploitation or duress. Again, you've been cured of your sexual addiction, or, you were engaging in a sexual relationship while at work, and that has since stopped, and it's been a long time. Obviously, I'm just throwing out some examples there, but those are also things that could potentially be utilized for some mitigation. The sexual behavior is strictly private, consensual, and discreet. This is, one that you could potentially argue for, again, kind of a workplace romance. If there's also a situation where somebody's accusing you of something, but, it was private, it was consensual, and maybe they're a scorned lover and they got, angry because you cut everything off and they made some, false accusations. You could potentially provide some proof that fall under that category. And then also, the individual has successfully completed an appropriate program of treatment or is currently enrolled in one. So this is also, again, if there's some sort of sexual addiction or some sort of other underlying mental health condition that maybe contributed to this behavior. And then there's some sort of treatment that you have gone through in order to kind of mitigate those concerns. So those are typically the mitigating concerns that are applicable for this particular guideline. That the adjudicators typically do look at, when they have security concerns that are, trigger this particular guideline. While Guideline D can cover a lot of topics, there is a common theme that we see for this guideline. Just like any other guideline, there's things that we see more consistently than maybe other potential circumstances. So typically for Guideline D, the security concerns relate to either soliciting or engaging in prostitution, or obtaining sexual favors through massage parlors. Those are usually the main ones we see because they're more common. People do that kind of behavior more frequently. So those are the ones we typically see that trigger this guideline. There are other aspects as well that we've seen, such as sexual harassment, again, whether inside or outside of the workplace, alleged sexual harassment by even, potentially family members, or sexual addiction. Any of those things, we see, in my practice, I've seen, a lot more heinous acts, I would call them, that fall under this guideline as well. But for the most part, as I said, the soliciting and engaging in prostitution and the massage parlors are typically the most common things that we see for this particular guideline. As far as some cases that I've seen, I mentioned earlier, obviously the massage parlor cases, those are typical. A lot of times individuals are going through a stressful time, whether it's, emotionally, mentally, they're having some marriage problems, whatever the situation is, that kind of pushes them to this, situation again, whether it's a massage parlor or, soliciting prostitution, and they kind of get embedded in that kind of behavior, whether it's once or typically, multiple times. I've definitely seen circumstances like that. A good piece of mitigation for those types of cases is obviously stop doing it. For a significant period of time if you can, get the necessary help that you need, whether it's to patch up your marriage, whether it's to, get your own counseling, things of that nature. Another one that I've seen, that I've dealt with is, somebody who solicited prostitution and being caught by vice police. And they've actually been, caught by an undercover cop, basically. We've been able to, in both of those cases, the massage parlor and also being caught by vice police and being charged with solicitation of prostitution, we've been able to mitigate those concerns through various different means. Obviously the best aspect of mitigation here is to not engage in this behavior, but there are some aspects that you can utilize in order to mitigate those potential concerns. And it's important to note too that, this is not all just what can happen in the United States. This can happen both in and outside of the United States. I've seen this guideline triggered when the act was engaged in another country where that was actually legal. Some prostitution's legal in other countries and across the world, and even in locations in the United States and places in Nevada, places like that. So just because it's legal in a certain place doesn't necessarily mean that it's not going to trigger this guideline. So obviously Guideline D is not as common as we see. Like I said before, it's more common than others, but these are the typical things that adjudicators look for under this particular guideline. So there you have it for this month's NSLA podcast. As always, please keep a lookout for more content to assist with your current and future security clearance journeys. Thank you for listening, and we look forward to you tuning in next time.